Hi there. Thank you for joining me. My name is Shabnam Akrami. I'm the managing partner of Akrami & Associates. And today we're doing a free live session, free consultation for clients. And so people have joined in. Welcome. I have received a few questions and feel free to ask more questions if you would like. And I can try to address them during this session. So let's get right into it. Right now, I have summarized the questions into six main questions based on the clients, what they've requested. So we'll go with the first client who is saying, hello, I want to know about how I could get my PR in Canada in a very less time. I'm an international student for now. So that's, again, as we've discussed in the past, it's a very, very broad question. You're asking for options and it doesn't give me a lot of information to really assess your situation. But if I just go based on what I've received here, it's saying that you're an international student, which means you're most likely still studying. And the main option that most people use is once you finish your studies, so long as the DLI number, the school that you're studying, allows for a post-grad work permit, you will then apply for the post-grad work permit, work in Canada for 1 year under NOC A, B, or O, and then apply under express entry. And then that could take several months to process as well. So everyone wants the fastest way to get permanent residency, and unfortunately, fast means different things for different people. Most PR applications take about a year to process, and that's from the time of eligibility. Right now, based on this particular applicant that has messaged us, it doesn't appear that you're eligible. The other things you can look at and see if you qualify under the federal skilled worker application, which is if you have 1 year work experience outside of Canada. And perhaps if that's the case, then you could potentially apply under express entry now. And if you do have work experience outside of Canada and you meet the eligibility requirement under express entry, we highly encourage you to create your profile now, because the draws are going to happen sometime in the month of July of this year. So, but from what you're telling me, it appears that you're probably young, a student who's studying and still studying in Canada. You haven't completed your education. So in that case, you have to kind of be patient, finish your education, find a job, get a job offer, work for 1 year, and then apply for permanent residency. Now, the second question is a little bit more specific. So it says looking for options for permanent residency back and want to come back to Canada. I don't meet the residency requirements. So I understand what this applicant is asking. They are saying that they have permanent residency, or they had a PR card. That card has now expired. They don't meet the 730 days residency requirements in the last 5 years, and so they're kind of stuck outside of Canada. We have lots of clients in this situation, and the application we have to submit is called Permanent Residency Card Renewal with Humanitarian and Compassionate Arguments. So ultimately, you're asking a renewal on the card, and you're making agency arguments as to why you don't meet the residency. There's a lot of content on my website on this matter, and I've done numerous videos on this. And ultimately, the officers are looking for why were you outside of Canada? What made you not meet the residency? And any argument is accepted, but the three highest approval rates, if you will, is if you didn't meet the residency based on employment obligations back home. Perhaps you tried to come to Canada, find a job, you couldn't, and then you were forced to go back to your home country or a different country for employment reasons. The other reason is family emergency. Something happened to your close loved ones that required your immediate attention. So I have tons of clients who came to Canada for a better life. A parent got significantly ill. Perhaps one of the parent passed away, and a mother was left alone. And so I have many clients who had to go and attend to an elderly parent, and then COVID hit. And so there's a lot of factors that prevented them to come back to Canada. And the third is if there's a best interest of a child. Sometimes there's children involved, young children involved, and it's in their best interest for the parent to come back. Sometimes the children are still in Canada, or even if the children are with you, it is always argued that it is in the best interest of the child to continue their education here in Canada, to make a life for them in Canada versus back home. So these are the three main umbrellas when you look at H&C arguments. Obviously there's other ones, but ultimately the officer looks at why did you leave and how do you prove to me that you're going to come back and stay. And so they look at ties to Canada, they look at your ties overseas, etc. So again, it's called PR card renewal with H&C. We have tons of experience in this. Do call me and we can assess yours and tell you exactly what we need to do. This is a type of application that you do have to be patient with, because it's not a 1 month processing time. A lot of people confuse it with the regular processing time of a PR card. When you do meet the residency obligation, a PR with H&C can easily take 12 to 18 months. And so it's about getting it done right, not about getting a decision quickly. So if you have questions about this, do give me a call. Another client is saying, hello, thank you so much for a free consultation session. My mom's super visa and passport is expiring September of 2022, but she already got a new passport. Is she able to travel to Canada on a new passport with super visa on the old passport? So this is a very good question, because we do get that a lot. And the answer is no. So if you have a visa in a passport, let's say in passport A, and that visa is still valid, but your passport is expiring, you unfortunately have to reapply go through the whole process again for the new visa. Now, your chances of approval are obviously very, very good, but you do have to go through the whole process again. You have to resubmit the super visa application, you have to resubmit the passport, you make the arguments that you do have a visa that's still valid, but you cannot go to the border and show them one passport that's valid and the other passport that has an expired passport that has a visa that's valid. So the visa and the passport need to be in the same passport. So that's very important. And I know clients always ask, well, how come the officer issued the visa longer than the validity of the passport? It's a good question. They shouldn't do that, but from time to time it does happen. So if your passport is about to expire or has already expired and you have a valid visa in that passport, you have to reapply with the new passport and get the new visa stamped again. You once again go through the LICO requirements, the medical insurance, the whole 9 yards. You have to redo it, but it is chances of you getting the super visa, is extremely high. I have another client who's saying, I've met a woman from Vietnam. I want her to come to Canada and visit me. Which is the best way to get her, as I've heard I can sponsor her? So it's a little bit vague. It's saying that I've met a woman, which implies that you're not married or in a common law relationship, or potentially not even in a conjugal. So if it's just someone you're seeing or dating, then no, you cannot sponsor. You use the word sponsor when you are able to apply for permanent residency for that person. And as a girlfriend, for example, you are not eligible to sponsor someone. However, you can apply for a visit visa for her, for example. But to sponsor her to apply for permanent residency, she needs to either be your common law partner, which is you guys have to be living together for 12 months and continue to reside together, or you have to be in a conjugal relationship, which can be a little bit tricky because that states that neither of you can be together because the laws prevent you from being together. So not everyone qualifies for that. And then, or you have to be married and then you can sponsor her. Otherwise, you have to apply for a visit visa for her. And once the visitor visa is approved, when she's physically in Canada, should you guys take the relationship to the next level and you get married to her, let's say at City Hall, at that point you can sponsor her and she can continue to remain with you under the inland spousal sponsorship application. So At this moment, based on what you're telling me, the visitor visa seems the best option. But if you want to go straight to sponsorship, then if you're not married to her, then obviously you'd have to fly to Vietnam, get married, file the spousal sponsorship, and take it the other way around. Okay, next question is saying, my sister is here on a visit visa. How can she change it to a work permit so she can start working? In order to change your status from one to another, you need something. So if you're a visitor and you want to work, you need a job offer. And depending on the job offer and depending on your country of citizenship, the routes vary. So for example, if your sister is American and there is a job offer that's under the NAFTA list, then you go and get the work permit at the border. If you're not under any of the agreements that Canada has with certain countries, then the chances are you're going to have to go through a process called labor market impact assessment, which sounds very scary because a lot of clients say, oh my God, I've heard about this and it's a long process and the approval rates are low, which is actually incorrect. Canada knows that we have a lack of specialized knowledge in Canada. And so long as it's done right, approval rates on an LMIA work permit applications are actually extremely high. That being said, you have to do it right. You have to post the position properly. You have to make sure it's per the prevailing wage. You have to provide the officer with the corporate documents of the company, etc. And so it's not a scary process. In fact, it's one of my favorite applications to submit. But it is work. And depending on where your sister is from, it could take anywhere between same-day processing to, let's say, 6 months. And it's a two-stage process. The employer has to be approved first, and then the applicant submits the work permit based on a positive LMIA. So it's not as easy as, okay, I'm a visitor, now I want to change it to a work. No, you have to have an employer. And if you're asking about an open work permit, which ultimately means that it's not specific to one employer, she won't qualify for that. There's different requirements for that. That's if you have to have something to get the open work permit. For example, you need to have a postgrad work permit is an open work permit. When you do an inland spousal sponsorship, that comes with an open work permit. That kind of things. Okay, sorry. Let's see. Then, please, can a caregiver stream work for a person whose siblings run the company in Canada? A caregiver is divided into two streams. So I'm not sure if you're asking about the elderly or if you're talking about children to take care of a child. That being said, probably not if you're asking a question about can a company do it. When you do any type of caregiver application, you need to include a CRA number, and that is your personal CRA number. So a company cannot do a caregiver application. It has to be the employer, and the employer is an individual, not a company. So for example, if you're talking about a small child, you need a caregiver for that small child, then it is you who's sponsoring and you are the employer. If you are self-employed, you cannot have your company. Ultimately, it's you, the employer. So if you are self-employed and you have a company running, you cannot put that CRA number there. So again, it has to be an individual. And part of the document checklist makes that very, very clear. Okay, so that's that. I see some additional questions. So we'll just, due to time, I mean, there's a lot of questions, but I'll try to summarize them. Okay. This again, trying to understand the questions. I'm from the Philippines and I want to ask about a case that's dismissed 20 years ago for attempted murder. I have all my records dismissed. So I guess there's no question there, it's just a comment. But If you have a criminal record and you want to enter Canada to visit, we have to do the equivalency to the Canadian Criminal Code. So we do respect and acknowledge the decisions that are made overseas, but that doesn't necessarily mean that that's the way the court system would have handled it in Canada. So what happens if, let's say, 20 years ago, you're saying that you were charged with attempted murder, but then the case was dismissed. Now, certain countries dismiss it after you serve a sentence and et cetera, et cetera. If that's the case, then that offense gets equated to the Canadian Criminal Code. We evaluate if it would have first of all been attempted murder or would have been murder or whatever. What's the equivalency to the Canadian Criminal Code? That's one. Second, what did you have to serve and complete for that sentence, for that offense? And how long did it take you to complete it? There are a lot of factors that are taken into consideration. So I'm assuming your question is, if it's dismissed, can I just freely enter? Not necessarily, because just because the Philippines dismissed the case doesn't mean Canada would have. And so especially with an attempted murder charge, I mean, that's quite significant. That's what we call an indictable offense. At the bare minimum, prior to you making any travel arrangements, I would submit an application to the consulate and say information only. This is the facts of the case. This is what I was charged with. This is what I had to complete. This is the end result. Kindly give me your opinion if I should apply for an application or not. But again, I can do that once I get all your documentation and say the equivalency would have been this. Sorry. So prior to making any travel arrangements, I would, with that type of offense, I would get a consulate letter to say that you're free to travel. If it was a minor offense like theft under 5, then perhaps I would have stated something different, but not with attempted murder. Okay. It says here, I'm in Saudi Arabia working for 10 years. I plan to apply for permanent residency in Canada. Do I admissible? Please, need your advice. So again, the answer is not as simple because you're just telling me your country and the fact that you have work experience. I don't know what type of work experience. Is it a NOC A, B, or O? How old are you? Do you have education? So if you look at the big umbrellas, if you want to apply under the economic route, you have to look and review something called express entry. They evaluate you based on your points, age, education, language, work experience. And the points that you want to score to have a good chance is around 450 for a draw. So by you saying that you have 10 years of work experience and you're from Saudi Arabia, it's hard for me to evaluate exactly what your points are. So if you want me to calculate your points, give me a call and I can give you a rough estimate as to how many points you have and what we can do to improve those points. I'm assuming if you have 10 years of experience, you're probably over the age of 40, which means you're going to have lower points on age. Based on just the writing and the punctuation on this message, I'm going to say that your level of English is probably an IELTS level 6. So if I had to really guess based on just this bare minimum, I'm going to say you're going to struggle by applying directly to express entry. We have to find ways to improve your points. And if I just had to guess based on this minimal information, you're probably scoring low 400s, and we want your points to be around the 450. Okay, so I think that's it. So I'll give, I guess, a minute to see if there's any other any other questions that I can address here in the free session. And if not, feel free to email us at info@thevisa.ca. We get tons and tons of questions. The consultation fee at my firm is only $75. You get 30 minutes. You get a direct answer. It's, in my opinion, worth that money to spend to get a specific answer. But at least you get an understanding of where you stand for those individuals who've asked questions. But if I did free consults for every client, it would take me all day just to filter through all the questions. So I charge a very, very low and a very competitive rate, and I think it's worth your time to invest in that, because at the bare minimum you're going to get your answers as to, is Canada a route for me, what are my ways, and how long would it take, a realistic understanding of how you can hopefully immigrate or remain in Canada. And having that peace of mind, knowing the answers, I think, in my opinion, $75 is worth it. And rest assured, if you retain the firm, we always credit that 75 back to you anyway, so you don't lose that 75. Otherwise, do send me your questions. We do weekly free sessions, and if there's any other questions I can attend to, I'd be more than happy to. Thank you very much for joining, and until next time.